everyone, and welcome to this Federalist Society virtual event. My name is Emily Manning, and I'm an Associate Director of Practice Groups with the Federalist Society. Today, we're excited to host a Courthouse Steps oral argument discussion on Ohio v. Environmental Protection Agency. We're joined today by Megan Herzog, Matt Kuhn, Viktoria Seale, and our moderator today is Matt Leopold, partner with the law firm of Hunton, Andrews, Kurth in Washington, D.C. He previously served as the General Counsel of the United States EPA, where he was involved in defending EPA rulemakings in the court. He also served as the General Counsel for the Florida Department of Environmental Protection. And early in his career, he was an attorney at the U.S. Department of Justice, Environment and Natural Resources Division. If you'd like to learn more about today's speakers, their full bios can be viewed on our website, fedsoc.org. After our speakers give their opening remarks, we will turn to you, the audience, for questions. If you have a question, please enter it into the Q&A function at the bottom of your Zoom window, and we will do our best to answer as many as we can. Finally, I'll note that all expressions of opinion today are those of our guest speakers, not the Federalist Society. With that, thank you for joining us today, and Matt, the floor is yours.
Thank you, Emily, for that introduction, and welcome again, everyone, to the Federalist Society's Courthouse Steps on the oral argument in Ohio v. EPA, which the court heard a week ago today on February 21st. My name again is Matt Leopold, and I'm moderating today's event, and I'm pleased to have with us some incredible panelists to break down this complex case and give us insights into what the court might be thinking on this matter. First, I'd like to introduce Matt Kuhn, who serves as the Solicitor General of the Commonwealth of Kentucky. As Solicitor General, Matt oversees the office's civil and criminal appellate litigation and supervises the office's filing of amicus briefs. He's argued in the Supreme Court of the United States, the U.S. Court of Appeals for the Sixth Circuit, and the Supreme Court of Kentucky. He previously served as Chief Deputy General Counsel for the Governor of Kentucky and in private practice at the law firms of Jones Day in Washington and Stoll, Keenan, Ogden in Louisville, Kentucky. He also served as a law clerk for Judge Raymond Grunder of the Eighth Circuit and is a graduate of Furman University and Columbia Law School. Next, we're pleased to have with us Megan Herzog. She is a Massachusetts-based attorney whose practice is focused on environmental, natural resources, and energy litigation and administrative advocacy. Megan is a 2011 graduate of the Stanford Law School, where she was co-editor-in-chief of the Journal of Law, Science, and Policy. She also holds a Master's of Science from Stanford in the Environment and Natural Resources. She has had fellowships at the Environmental Law Institute in Washington, D.C., and at the UCLA Law School's Emmett Institute on Climate Change and the Environment. She previously served at the Massachusetts Office of Attorney General in the Energy and Environment Bureau, and she has led state government coalitions in several actions in the U.S. Supreme Court and the U.S. Court of Appeals for the D.C. Circuit and before the Federal Energy Regulatory Commission. We're also very fortunate to have with us Viktoria Seale. Viktoria is a Regulatory Affairs Director for the National Rural Electric Cooperative Association, which represents nearly 900 not-for-profit electric cooperatives and other rural electric utilities. She advocates before the federal government for NRECA members on environmental, permitting, and other regulatory issues. Viktoria has extensive federal government experience and has worked on a wide range of complex legal, regulatory, and legislative policy matters. Prior to joining NRECA, she served as the General Counsel and Chief of Staff for the White House Council on Environmental Quality and helped lead significant initiatives, including the comprehensive update to CEQ's NEPA regulations. Viktoria is a graduate of Rhodes College and received her JD from Chicago-Kent College of Law. So with that, I do want to provide a little background on this case as it arises in an unusual posture of a petition application for stay pending appeal with the U.S. Supreme Court. And generally, the court must decide two basic questions. Whether it should stay the EPA's federal emissions reduction rule, known as the Good Neighbor Plan, and whether the emissions controls imposed by the rule are reasonable regardless of the number of states subject to the rule. A little background on the Clean Air Act and how this case arises. The Clean Air Act is a statute that embraces a model of cooperative federalism to address nationwide air pollution and provides an essential role to state regulators. EPA is charged with setting national ambient air quality standards that are uniform across the nation for certain air pollutants. And the states retain the primary responsibility of assuring air quality within their borders. Relevant to this case, EPA issued the 2015 Ozone National Ambient Air Quality Standards. And in issuing these standards for ozone pollution, it triggered states' obligations to update their state implementation plans, or SIPs, under the Act. The Clean Air Act recognizes that air pollution is transient and heedless of state boundaries, and it may be transported by air currents from upwind to downwind states. To account for these obligations, a state plan must address activity within the state that emits air pollutants in amounts that will, quote, contribute significantly to non-attainment or interfere with another state's maintenance of any air quality standard. This statutory requirement is known as the good neighbor provision, and it is Congress's chosen method of balancing interests in upwind and downwind states. States typically meet these obligations by crafting SIPs, or state implementation plans. Among other things, SIPs must show that the state will comply with the Act's good neighbor provision, which importantly requires upwind states to reduce emissions to account for pollution beyond their borders. But if EPA determines that a state has failed to meet its good neighbor obligations, it may disapprove a SIP and issue a federal implementation plan known as a FIP. That is exactly what EPA did here that gives rise to this dispute. Numerous states have asserted, however, that the Clean Air Act is clear that if a state plan meets the Clean Air Act requirements, EPA shall approve the SIP. To craft the federal implementation plan, EPA used a four-part approach. First, they used modeling and monitoring data across the 48 contiguous states to identify areas known as, quote, receptors. Second, EPA used that modeling to quantify pollution contributions from upwind states to the receptors in downwind states. Third, EPA identified upwind emissions that, quote, contribute significantly to non-attainment, and used cost effectiveness of assessments of potential emissions controls. And finally, EPA proposed to enforce control measures to prohibit those significant emissions. Examples of the emissions controls that EPA mandated are enhanced operation of existing controls at power plants to address nitrogen oxide emissions. And also, EPA required for the first time installing new control technologies to address emissions reductions for other industries such as natural gas pipelines, cement kilns, steel industry reheat furnaces, and paper industry boilers. The federal plan also allows for banking and trading of unused emissions allowances and a new approach called dynamic budgeting to prevent surpluses from accumulating and reducing stringency of the plan. With that backdrop, this case was brought before the Supreme Court by Ohio, Indiana, and West Virginia, as well as 8 trade associations and 7 companies. Ohio submitted its plan in September 2018, and Indiana in November of that same year, and West Virginia in February 2019. But in February 2022, EPA proposed to disapprove submissions of 19 different state plans. And a few months later, EPA disapproved 4 more, bringing the total number of disapproved SIPs to 23 states. Approximately 2 months after proposing to disapprove the SIPs and before the deadline to commenting on the disapproval expired, EPA proposed the federal implementation plan addressing regional ozone transport, aka the Good Neighbor Plan. This federal plan sought to resolve the good neighbor obligations for roughly half the country. In separate litigation in regional circuits around the nation, various states filed petitions for review of EPA's disapproval of the 12 SIPs, and those circuit courts have stayed EPA's disapproval as to those 12 SIPs pending disposition of those cases. Importantly, that means that EPA's federal implementation plan cannot move forward in those 12 states for the time being. The 3 states and industry participants here took a different course. They filed petitions for review in the DC Circuit, challenging EPA's federal implementation plan and seeking a stay pending appeal. but on September 25th of last year, the DC Circuit denied the parties' applications to enter a stay. Shortly thereafter, on October 13th, the states filed an application for stay with the Supreme Court, and in a unique development, the court set oral argument on the motion. So one more thing before I turn to the panelists. I wanted to recite just the basic, relatively familiar standard for stay pending appeal, which is at issue here because some have argued that the court might hold the applicants to a higher standard. But just to review, that standard is whether states have shown the likelihood of success on the merits, whether the stay will substantially injure other parties interested in the proceeding, and whether there will be irreparable injury absent a stay, and where the public interest lies. So with that, I want to turn to our panelists, and I'll ask Matt, as the only government representative on the panel, if you'd go ahead and start us off.
Well, thanks for the invitation to speak about this really an important litigation. And though I'm the only government person on here, both upwind and downwind states do have a very significant interest in this case. I'm on the upwind side of it. So let me place for you. I want to make 3 quick points before we get to some questions to help frame. The first is to explain what my state, Kentucky's role has been in this. We are one of the 23 states whose SIP was disapproved, and as a result, we're one of the 12 states that got a stay of that SIP disapproval. And so we got our stay in the Sixth Circuit, first as an administrative stay in May of last year, and as a full-blown stay in July of 2023. So we are similar to the stay applicants in the sense that we had our SIPs disapproved, but we're a bit different than especially Ohio and Indiana in the fact that we have a stay. And so that's why Kentucky is not seeking emergency relief from the U.S. Supreme Court, because we're protected by the Sixth Circuit stay. But Kentucky is part of the reason our sister states are seeking emergency relief from the U.S. Supreme Court. So Kentucky is very much interested in what happens at the U.S. Supreme Court in Ohio versus EPA, but we are a bit on the outside looking in. The second introductory point that I wanted to make is just to impart from an upwind state perspective how important our SIP disapproval litigation is. We didn't just file this to gum things up and make it hard for the EPA to impose a follow-on federal plan on us. Our agency in 2019 proposed our SIP, spent a lot of time on it. It's a lengthy document, a lot of thought and effort went into it. And we did not get a SIP disapproval until almost 2 years after the EPA's deadline to act. And surprisingly, when our SIP was disapproved, they relied on an entirely new data set that we had not gotten the opportunity to utilize. And that data set changed the sites that we're linked to. So our state had no opportunity to engage with the data set that the EPA imposed to disapprove our SIP. The EPA disagrees, but we think that's a pretty textbook violation of sort of arbitrary and capricious the standard from the APA. We sued, as I've noted, and we're one of the states, the 12 states that got a stay. EPA's record in this SIP litigation so far is not very good. By my count, they've lost stay motions in the 4th, 5th, 6th, 8th, 9th, and 10th circuits, although the 10th has now been transferred to the DC Circuit. So the SIP litigation is related to the FIP litigation, but at least in the upwind states view, it's very meaningful litigation. The third point that I'll make, and it's just a general observation about the oral argument last week, is I think panelists here, we can disagree about what the right answer is, but yet one thing I think there may be general agreement about is that it was good that oral argument was held. This is very complicated, and the more the justices can look at this closely and ask questions, I think the better. One of the more interesting exchanges at oral argument was Justice Kavanaugh getting the federal SG's office to concede that oral argument was a good thing. In particular, I think several members of the court are interested in talking about the standard for seeking emergency relief, something that we've seen. We've seen a lot more emergency requests, but we haven't seen really a serious. I guess we've seen an argued case, but we need to see more argued cases with more clarification about what that standard is. So apart from the CAA issues that they're going to resolve, my expectation is that we'll get some clarity for stay applicants and those opposing stays on how to approach it. And I think oral argument on that issue was a very good thing.
Thanks so much, Matt. Megan, let's turn to you for your thoughts.
Thank you. I'm so pleased to join today to share some insights. I'm counsel for Environmental Defense Fund, which is one of the health and environmental organization interveners supporting EPA in this litigation, though my remarks today, I'm just speaking for myself. And I thought I would also highlight 3 things about last week's argument that particularly stood out to me. So the first is, I think there's extraordinary fact that this is a case where the core claim is a procedural one. And the fact that that kind of case is not a case where applicants' main claim is that EPA lacked statutory authority or a major question or anything like that. It became clear at argument that what the applicants are instead arguing is that EPA failed to provide enough explanation as to why the rule remains reasonable, even if one or more of the originally covered 23 states dropped out, as has at least temporarily happened here because of the stays in the separate litigation. So the applicants aren't claiming that there's a practical problem with the 11-state rule, which is working fine. And they've even conceded at argument that the number of states might not make any difference. So the real upshot here is that the rule could be valid if EPA had just said a little bit about the states dropping out under their theory. So I think it's quite unusual for litigants to seek a stay of a federal rule from the Supreme Court on the basis of a procedural claim like this. And there are sort of a few reasons, right? It's a principle of administrative law that procedural errors only matter if they're prejudicial. The Clean Air Act has its own particularly robust harmless error rule for important public health rules like this. And on top of that, where we have a rule like this that's providing health benefits to millions of people, even if there were a serious substantive infirmity, the rule would typically be left in place while the agency corrects it. So this is even a situation where the remedy that applicants could show a likelihood of winning on the merits is remand without vacatur. So we could have a situation where the Supreme Court, if it stayed with the rule now on grounds of an allegedly insufficient explanation, it could actually give the applicants more relief than they would get if they ultimately prevailed. So all of this makes, I think, for an extremely unusual set of applications, and it highlights how one of the consequences of a stay grant here could be to invite more emergency applications to the court in circumstances where I think many litigators would previously have thought or would not be entertaining a possibility of granting stay. The number 2 thing that struck me about last week's argument was how the court engaged in balancing the harms, or maybe more rather how it didn't do so. So the court, this is only the 3rd time in the last half century that the court has an argument without merits briefing. So maybe it was unsurprising that the justices seemed to fall back into the usual role of acting like it was an ordinary merits argument. But I thought the lack of interest from the bench, at least an argument in sifting and weighing the evidence of harms was pretty striking. So this might be typified, for instance, by statements from the bench that harms to regulated industry and to the public and the states who are beneficiaries of the rule were awash, that there were states on both sides, and the sense that therefore all that's left for the court to do is to decide merit. And there were some questions that keyed in on issues of cost, interrogating industry counsel about whether they in fact experienced the cost they predicted while the rule was in effect. But then counsel fell back on the declarations that were made many months earlier. And there was just this sense, I think, that the court wasn't yet sure how they should approach the task of assessing the strength of the evidence and rebuttal evidence and how to go about weighing the complex records in the case. And there was a suggestion from applicant's counsel, an argument that the state standard would be akin to something like checking the boxes of unrecoverable. And that standard would, I think, also, if followed by the court here, be not only disruptive to important regulatory programs, but could again invite more emergency applications they might not have expected. And the final thing I'll note that was surprising to me was, I think, the lack of attention to the statutory context for these state applications. So as I mentioned earlier, the suggestion arose at argument that both sides claimed harm, everything then turns on the merit. And this premise seems particularly flawed in the context of the good neighbor provision, where Congress recognized that upwind states are getting the benefit of their economic activity while exporting health and environmental states who are then to deal with all the costs of pollution. And this is an instance where Congress made the judgment that upwind states have to eliminate their significant contributions. And the statute sets forth the requirement that every area of the country achieve minimum standards by particular deadlines and imposes rationing consequences for failure to do that. So in this context, a stay that leaves pollution unremedied would seem really at odds with Congress's basic judgments in the Clean Air Act. And it didn't seem to me like the court, at least an argument, was really grappling with the statutory text. These are all reactions to the argument that may or may not ultimately be reflected in the court's decision, of course, but I appreciated the chance to share thoughts, and I'm looking forward to hearing more from the rest of the panel and discussing.
Thanks so much, Megan, for those insights. Victoria, let's turn to you. I think you're muted at the moment.
Thanks, Matt. Sorry about that. We too appreciate being included in this panel discussion today. As Matt mentioned, I'm a Regulatory Affairs Director for the National Rural Electric Cooperative Association, or NRECA, which I use the shorthand since our trade association name is long. We are a party to this emergency application for a stay pending before the Supreme Court. I will say that I'm also going to be making these remarks based upon my own individual impressions on the argument and so forth. But I thought it might be helpful to start out by providing a little bit of background about the folks that we represent. So these are the nearly 900 not-for-profit electric cooperatives that serve 42 million people in 48 states, or nearly 13% of the nation's population. So we're an unusual part of the electric utility industry. We are owned by the people we serve. So we're not for profit. We operate at cost and without a profit incentive. And of course, being based in the communities that we serve, our members are really committed to providing safe, reliable, and affordable electric service. And affordability is really front of mind, as well as reliability, as our members serve 92% of the nation's persistent poverty counties. So these are areas that are sparsely populated, primarily residential, and often the most expensive and hardest to serve areas of our country. And because of this kind of territory that we cover, our folks are also the ones that maybe can least afford increases in costs. Because of the way that our members are structured as nonprofit entities, we have no investor equity shareholders who can bear the cost of stranded generation assets or investment in new or alternative generation resources. So consequently, the full burden of regulations that affect our members affect actually their consumers at the end of the line. So turning to the rule and the argument that we heard last week, I might differ a little bit with the previous panelist, and that I do think that it wasn't just procedural issues that were addressed by the applicants, but really substantive questions. Not just that EPA did not consider a smaller version of the 23 state plan that it originally designed, but that it really, that kind of goes to the heart of whether or not they would have designed the same plan for a smaller group of states. I'd also say that, clearly a critical issue is this question of irreparable harm. And I think one thing for folks to understand is that even if, and in this case, some of these requirements don't go into effect until 2026, 2027, that doesn't mean that compliance doesn't start now or really before when the rule went final. It takes many years for utilities to go through the process of deciding whether to undertake NOx control upgrade projects for specific units. Among other things, they're going to have to engage in design, engineering, procurement for our members in particular, because they often finance pollution control projects using federal financing. The National Environmental Policy Act is triggered, NEPA. So there are just a lot of different considerations, a lot of different components to coming into compliance with the regulation. And it doesn't happen 3 years down the road. It happens now when the rule takes effect, that process has to begin because it is lengthy and there's a lot involved in it. So just to kind of, I guess, provide that clarity, as far as, impressions from the argument, I think that, I came away from the argument thinking that the two justices that were maybe the most difficult to read in terms of where they might be going on this stay request is Chief Justice Roberts and Justice Amy Coney Barrett. And their questions didn't reveal as much as maybe others did. So I'll stop there and just look forward to engaging in this conversation about the oral argument last week.
Great. Thank you so much for your remarks and everyone's remarks. And I wanted to just remind folks that before we get into some questioning with the panel here, that we will take questions online, and please submit your questions for the panelists through the Q&A function throughout, and we'll have time for audience questions at the end. So first of all, I want to get back to something that a number of you have mentioned is this extraordinary posture that we find this case in, where we don't have a ruling below in the DC Circuit yet. Matt pointed out that Justice Kavanaugh quipped about oral argument making this better. But that being said, what are your thoughts about why the court took this case? And given that it's pretty unusual, and I have some of my own thoughts, perhaps the federalism issues, but what do folks think about why the court deemed this important enough to take this case?
I'll kick it off. So a couple of things. I think the Supreme Court in the last 3 or 4 years has been pretty active in looking at big cases about the federal exertion of power. I think that, and even doing some on the emergency docket. Megan mentioned how unprecedented this is in the last 50 years, but the OSHA vaccine mandate case was the last time that oral argument was granted on a stay application like this. Before that, the time previous was 1971. But again, my point is, I think we've seen the court active on the emergency docket in cases that involve federal exercises of power. And so, Alabama Realtors is one, the OSHA vaccine is another. And so I think it's consistent perhaps with that. I do think the court has also another aspect of this is the agency that was involved, the EPA. The court has, in the last couple of years, seemed pretty skeptical of some things the EPA has done, from the Sackett decision involving the WOTUS rule, where the EPA issued a new rule while the case was pending there for a decision. And a key part of that rule got 0 votes at the U.S. Supreme Court in the Sackett case. I think West Virginia versus EPA is another instance of that. And I do think that the competing theories of harm here made this pretty interesting, with the upwind states, the downwind states, clients like Viktoria's client And I do think that made sort of added an interesting spin to this. And the last thing I'll say is that I think that the court's seeing more and more of these emergency requests. I don't think anybody would dispute that. And I think taking oral argument to spell out the standard a bit more. There was disagreement between the parties. You've got two frequent flyers and emergency stay requests in opposition. You got the federal SG and you've got the states, and we're active on the emergency docket, both of us. So we're all there. It seems like a pretty good vehicle to provide some guidance about that, which is why so many of the questions were focused on that. So I don't think there was any one reason why the court took review, but I think all of those sort of combined to make this a pretty good vehicle, not only to resolve the legal issue that we have here, but also some of the procedural aspects of emergency relief.
Thanks, Matt, for that. Anyone else on that question? If not, I kind of wanted to jump into something Matt alluded to, which was the standard of review and what is the proper standard of review for a stay application in this posture. What are, there was some suggestion in the briefing that there should be a higher standard, but the justices, some of them push back on that at oral argument. Can anyone offer thoughts about that and where that might be going?
I can at least jump in first with some thoughts. So yes, there was a lot of discussion from the bench and with counsel at argument about this concept of cert-worthiness or extraordinariness and where it fits in with the standard. Is it extraordinary harm? Is it part of the merit standard? Is it, how do we judge cert-worthiness in this posture, in this context? And I think the impression left was definitely that this is something that the justices are working through and grappling with. I think as an observer of that argument that there was a lot of discussion of this factor, but maybe not some particular attention to identifying a particular question of law or fact in this case that grappled with those standards. And so I'll be really interested to see, what the court says in its decision to the extent there is one. But one thing that I noted was also a lot of questioning from the bench, typified by Justice Jackson in particular, about how the failure to identify some kind of bar, cert-worthiness, extraordinariness, however we want to term that within the stay standard, could be to the effect of inviting a flood of emergency applications on the court's docket, which we know is something that not all of the justices are interested in. And so there's this sort of importance on clarifying this point to think about management of the emergency docket.
Go
I was
ahead.
just
going to say, Matt, just dovetailing with those comments, and I thought that the discussion of cert-worthiness, which really is peppered kind of throughout the oral argument, I thought it got particularly interesting when Justice Barrett started asking, the government if they thought that it was cert-worthy or would they ever, and I think that it seems that Justice Barrett, not only in this case, but in prior cases, seems to really be focusing on this, as an element of whether or not there would be success on the merits. Now, whether it's a separate consideration or it's just part of that, I think that was a little bit unclear. And you saw the kind of that conversation going back and forth in between, I think it was, and I'm probably going to be misspeaking, but perhaps Kavanaugh and others, and he and Barrett, I think in previous cases, have kind of explored this idea of cert-worthiness as well. I'm not sure if it's necessarily happened orally, but in writing as well. And I don't know if Matt wants to jump in on that too.
Yeah, I thought that the Barrett questioning on this was fascinating because she was the one in the Doe 1 through 3 versus Mills case that she wrote us a very short separate decision joined by Justice Kavanaugh, where she said that cert-worthiness is built into the idea of likelihood of success on the merits. And I think their thinking there was essentially that we're a court of last resort. You should not be coming to us in the ordinary course. And so therefore the 4-part McKinn standard, the 4-part stay standard, or the 4-part, there it was an injunction standard, which is a question of whether that applies here, but that, because we're a court of last resort and these should not be brought to us all the time, because we've got sort of a certiorari considerations, we need to build that in to the merit standard. And I think there was some agreement with Justice Barrett on that. Justice Kavanaugh, explained very directly why he thought this was cert worthy. Justice Jackson was also keyed in on that. And so I think there's an interesting kind of ideological agreement, perhaps, that cert worthiness may be built into this. Now, the state's position is that this is just a straight up stay standard, and that the cases about the cert worthiness are from an injunction pending appeal standard, and the state standard's just different. For example, if you look at the vaccine mandate ruling, that was a stay one, and there was no discussion of cert worthiness there, yet they granted a stay. So again, I think that's maybe one of the reasons the court took oral argument here, is to not only rule on the stay request, but to give guidance to the bench and bar, because they're getting more and more of these emergency requests.
Yeah, that I agree. Those very interesting exchanges, and could have broad sweeping impacts on the emergency docket of the court. Turning to some other issues that came up, there were some justices who were reaching out potentially for a way to resolve this on procedural grounds, and for environmental practitioners who practice the Clean Air Act. You're probably familiar with the Clean Air Act's reconsideration provision, that if something came up after the rule was finalized or promulgated that commenters couldn't have anticipated, the Clean Air Act does have a special provision to allow a motion for a petition for reconsideration. This was featured pretty prominently, and as a potential question about whether petitioners had exhausted their remedies. Any thoughts on that and how the court might resolve that issue?
Yeah, I'll weigh in first. I thought that was interesting. Justice Kagan had a really memorable question of Ohio's deputy SG, when she's like, "There's a lot of stuff here," and she said, "And stuff means vehicle problems." And one of the vehicle problems she pointed out was the reconsideration provision. The CAA has an interesting reconsideration provision, which if something arises that couldn't have prompted a comment that the agency could rely on, the commenter can then seek reconsideration. There's no real timeline. The agency can do what it wants with it, and then you can sue the agency in the DC Circuit if you want to. But the state's pointed out that reconsideration really has a limited ability to stay. It's only a 3-month stay, so I don't think that's a really full remedy for the states. Moreover, there were comments about the state implementation plan and the problems with the disapprovals of the SIPs. If you actually look at the final rule under consideration, it deals with those comments. The CAA's comment provision doesn't require exactitude. It requires reasonable specificity. And so I think this was pretty straightforward. On the reconsideration, Justice Alito had a great exchange with the federal government, just pointing out the limits of relief that some motions for reconsideration have in fact been filed about these issues, and they're just sitting there. The agency hasn't resolved on them. Chief Justice Roberts had a great exchange with the Solicitor General's office for the federal government, asking, do you plan to think about how the 11 versus 23 changes? And the answer was no. And so I although it is, to quote Justice Kagan, stuff, I think that at least in my view, again, I'm biased and this is just me speaking, I don't think that's going to be ultimately an impediment to the court ruling on the stay request.
I can just add, one thing that I think is interesting about this, and going back to, I'm glad that Matt Kuhn raised the Justice Kagan's comments about stuff, because I think that sort of highlights how unusual this argument and this case posture is for the Supreme Court, where they're thinking about things like exhaustion bars and whether issues were exhausted in comments and the adequacy of the agency's response to comments. And I think that these are the kinds of sort of record-based review type things, these kinds of skirmishes between agencies and regulated parties that are like super common in DC Circuit litigation over these rules, but are not something that we typically think of the Supreme Court as engaging in or sort of like wanting to engage in. And I think we saw just a little bit of that unusualness in this case, where I think this is an extremely complex record. And at times, I think the justices may have got a little caught up in some of the complexities. I think they keyed in on the recon issue in particular, but just speaking, more generally, there's a lot of complexities here, and it's sort of highlighting the sort of oddness of this sort of record review case being at oral argument in the Supreme Court.
Yeah, and I want to drill down a little bit on this notion of, was it possible for EPA to really anticipate that litigation subsequent to the promulgation of the rule would have set aside these SIPs, and therefore they should have anticipated that outcome? That was something a number of the justices were grappling with. And is that proper for reconsideration, or what are the limits on what the administrative agency has to look at?
Well, I'll just say, Matt, that clearly the agency did contemplate this because they included a severability provision, and that was something that wasn't included in the proposal, but rather appeared in the final. So there seems to be some contemplation of the fact that one of the states could one of the SIP disapprovals could have been found invalid, and therefore it wouldn't apply. So the questioning that went on about exactly, did they need to kind of look at every single permutation of combination of number of states that could be in or out? That I think kind of misses the point that they clearly understood by responding in that way and including that in the final rule, that there was some possibility that what they had finalized may not continue as it was. So.
Cool. Well, let me pose this to Megan. What do you think about the argument that with only 11 states participating, can there be a coherent federal plan as was initially contemplated by EPA?
Well, I think what I would say to that is that this rule was designed to be a remedy for each of the covered upland states addressed under the rule. And so what we have is a design and structure that was, from the outset, designed to be something that applied to each individual state, and that was, as EPA noted specifically in the rule, would work fine regardless of geographic state. And I think this is typified by the Clean Air Act itself contemplates that states can adopt a SIP and leave a federal plan at any time, that we have a long history of these rules where states come in and out, and where we have this sort of contemplation even in this rule itself that EPA will later come back and add additional states. And so it's sort of just infused cohesively throughout the rule. I think that it's hard to find an example of another program more explicitly designed to change in coverage of states. But that said, I think that in real time, the court was kind of grappling with all of these complexities and issues, and it'll be interesting to see when they go back to the record what they think.
Yeah, I think even at one point the court or one of the justices pointed out that, do we really need to have 23 separate FIPs? Matt, is that really workable or necessary for EPA to do 23 separate FIPs, or what's wrong with one FIP to address all the states?
Yeah, so I think Justice Kagan brought up that if we are you ask the states, are you really requiring the federal government or EPA to contemplate every different permutation? And I think the answer to that is pretty clearly no. I think Justice Kavanaugh was the sort of the most vocal advocate for this position, but I think Justice Gorsuch hinted at it as well, and the Chief Justice did. Part of the problem is, at least from the state's perspective, is that the federal government, the EPA's rule said it's severable, but didn't explain why, didn't explain how it would work, didn't explain if there's some sort of minimum quantum of states that have to be in the rule or not. I think the state's position is not that you need to consider every permutation. You just need to consider it. You need to give it reasoned consideration under the APA. And I think one of the most important questions from oral argument was the Chief Justice of the federal SG when he said, would EPA have proposed the same rule if the least emitting of the 23 states was the only state that was ultimately in the plan? And the answer was from the federal government was no. Well, so it has to be the case that at some point enough states drop out of this that EPA says, no, the plan doesn't work. And we don't know what that is because the final rule just doesn't discuss it. It says it's severable and it moves on. And as Justice Gorsuch pointed out, it says it's severable. They added the severability part of this in the final rule, and nobody got to comment on it. And so not only did they not explain it, they didn't give an opportunity to comment on it. And so I think that the notion that EPA should have considered every permutation just mischaracterizes what the states view as a problem with this plan.
Yeah, and a lot, I agree that a lot of the types of merits arguments that the court did consider seem to be more APA type arguments, right? And under State Farm and similar cases. I didn't hear much at all about the technical arguments that maybe industry's making. You know, Viktoria, how is the court supposed to get into those technical issues, or can they on this record before the court?
I mean, I think it's difficult to get into those technical issues, at this stage. And generally, right, difficult to get into these technical issues. I mean, these Clean Air Act rulemakings are extraordinarily complicated. And, in the current posture, the question before the court, I think, they really can't go there. However, they have to, as part of that question on, will the petitioners likely be successful on the merits, there's like some of that they're touching on, but clearly kind of the complexities of this rule and how it operates, and the concerns that petitioners have raised with the lawfulness of it, and it's all sorts of facets of it that are different than prior rules, are, I think, just beyond what the court could get into at this stage.
Right. I mean, can you shed a little bit more light on, what industry might be facing it, in some states versus others with all, because there's complex budgeting and trading and allowances that the court didn't really talk much about, but the rules certainly features that if it went forward only in 11 states that remain participating, it might create odd incentives or disjointed incentives.
Sure. So, as I mentioned earlier, sources that are, still are in a state where the underlying SIP disapproval hasn't been stayed, need to be determining what they're going to do to come into compliance with the rule now and taking steps to do so. And of course, as I mentioned, that may include deciding whether to undertake some sort of NOx control upgrade project. However, if a source determines that that's just not possible, maybe because of, features of their site, their particular plant, all sorts of other considerations, they're going to be forced to buy emissions allowances from other parties, decrease their production, or potentially cease operations altogether. And because there's going to now be fewer emissions allowances and higher demand due to 12 states being removed from the plan, there's the real potential that causes a lot of kind of upheaval in that market. And so there could be a significantly higher premium that these facilities will need to, to pay in order to obtain those allowances. So there's just a lot of complexities and impacts that are, occurring now. And we have, of course, members who are in states where, the SIP disapproval has been stayed, and the EPA has then come in and also, stayed the applicability of the rule. And then we also have members who are currently subject to the requirement. So it's a really complex landscape with now, only 11 states being subject to the plan.
Yeah, I will say complex litigation landscapes are not uncommon in EPA rulemaking contexts. I think, for folks who watch the WOTUS litigation, it's stayed in half the country, it's not stayed in the other half. There's multiple district courts considering those cases. But maybe Megan, to you, notwithstanding that, doesn't the agency and the downwind states have a pretty strong interest here that the harm that they're experiencing in their states needs to be addressed in the near term, because otherwise the upwind states are getting a free ride on the controls in the downwind states?
Yeah, that's exactly right. And I think Judy Vale, the counsel for New York, laid this out very well at argument. The consequences of the upwind contributions continuing under a stay is that the downwind states will have no remedy, even as they continue to face attainment deadlines under the Clean Air Act that aren't stayed, that are going to continue to go forward. And sort of for folks who maybe aren't quite as familiar with the Clean Air Act, we have sort of a structure set up here where states are required to meet these national air quality standards, and they're judged based on their highest ozone days in prior years. And then these deadlines continue throughout time. And so at any given moment, it's really important for these downwind states to have significant contributions from upwind states eliminated as they're trying to meet their air quality standards. And the consequences for failing to meet air quality standards are not just that their residents are breathing unhealthy air, which is really impactful at an economic cost, but also that there are statutory consequences that ratchet up for the downwind states that actually require them to impose further economic costs on industry in their own state. And so this isn't a case where those burdens would be lifted on downwind states under a stay. The attainment deadlines would continue to roll, and they continue to be subject to these consequences. And so that's sort of in the background, I think, of the harm balancing in this case too. That it wasn't clear that the court was considering a lot of that during the argument, but it's certainly in the papers, and something that I hope that they'll give really due consideration to as they reach their decision.
Yeah, that's right. There wasn't a lot of discussion of what the downwind states are facing, because the ozone NACs are not stayed while this litigation is going on. EPA is going to continue to require all states to come into compliance with the ozone NAC standards. So that is ongoing, and the backdrop against what the downwind states are arguing. But it does kind of raise maybe a question. I'll throw this to Matt. If the Good Neighbor plan is stayed altogether, it has baked into it compliance deadlines that that are going to pass during the pendency of the litigation, likely, right? And then of course, the big question is industry is not going to invest in controls until it knows the outcome and it has certainty on what the obligations might be. How is the court supposed to handle those deadlines and effective dates built into the rule?
Yeah, so I think that's largely, at least in our view, a problem of EPA's own making. EPA, of course, they had the legal authority to immediately impose this federal implementation plan so soon after denying all these state implementation plans, but they didn't have to. They had a 2-year window within which to work. concerns about downwind states. EPA delayed, almost 2 years past their statutory deadline to act on Kentucky. So I think, EPA talking about downwind states, they don't come to it with clean hands. If it was such a concern, they shouldn't have delayed 2 years past. I do think that, that the downwind states concerns are, of course, baked into what we're going to baked into the applicable standard. I think everybody agrees with that. I do agree with Megan. There wasn't as much discussion of that particular point at oral argument, though New York's counsel did do a good job, I thought, of focusing the court on that.
Good. I do have one question from the audience here, and it goes back to what we were talking about earlier about why the court might be motivated to hear this case. And the question is the EPA the agency that has the most decisions against it overall? If so, is this because they most frequently go past their authority? And so I think the questioner is getting at, is there some skepticism of some of EPA's actions developing at the court? Anybody want to tackle that one?
I don't have a tally of the respective agencies' sort of win-loss rate in the Supreme Court recently, but I think it is fair to say, it's, any even just neutral observer of the court, I think, would recognize that this court comes to cases involving EPA with, it seems like, some particular skepticism. And I think that sort of like brooding sense that whatever happened here, it was certainly EPA's fault, was something that came through for me, and kind of hearing some of the questions from the bench at argument. And so perhaps that's sort of a starting position, but this, just to reiterate, is really not a case about EPA's expanding the bounds of its statutory authority. It's really, at least in the core claim that applicants have raised, a much more procedural, as Matt was saying, APA type case. And so I think that really distinguishes it from some of the past cases that the court has taken.
Thank you for that. Well, we're getting close to time, so I do want to wrap up and give everyone an opportunity to make some predictions if you're interested. How do you think this case is going to turn out? Matt, we'll go to you with that.
Thanks for starting with me there. So a couple things. The first thing is the fact that there was such a lag between the state's application or the applicant's applications being filed and oral argument being scheduled. My memory is the applications were briefed November 1st, and we didn't get an oral argument until February. I think that suggests that perhaps the justices may have already exchanged some drafts, and that in exchanging drafts they realized they wanted to have oral argument. So I do think that we could see a quicker decision. If I had to guess, this is not an end of June decision, especially given the lag between the applications being briefed. On a prediction, I can't give you a vote breakdown. I agree with Viktoria that the hardest members of the court to read were the Chief Justice and Justice Barrett, and so I'm really interested to see where they come down, and either or both of their votes could prove dispositive. So I think that's about, I think that a lot of the media coverage has suggested that it's more likely that the applicants are going to get a stay. But these are hard cases. And I think one of the things that was enjoyable for me as a guy who struggles to understand the Clean Air Act, even though I'm litigating it, to see the justices struggle, it just gave me a shot in the arm to say, hey, it's not you. Even the height of our judicial system is struggling with the same issues that, you're struggling with in Frankfort, Kentucky. And so I think that was for CAA practitioners like me, I enjoyed seeing the justices struggle a little bit. And I think that's good for practitioners. And I think for the American public to see as well. These are hard questions. They're consequential. They matter. They affect upwind states. They affect downwind states. And so to go back to my point at the beginning, it's great for the public to see the justices struggling with these deeply consequential questions that are going to affect states from sea to shining sea.
Yeah. Viktoria, we'll go to you for closing thoughts.
It's hard to top Matt. I think he just really summed everything up, but it is a consequential case. I do agree with him that because there has been such a lag in timing that I would expect to see a decision from the Supreme Court sooner rather than later. But I won't make any predictions beyond that, but look forward to the outcome and appreciate the opportunity to participate in this discussion.
Thanks, Victoria. And Megan will give you the last word.
Thanks. Well, like Matt, I too was listening carefully to hear Justice Barrett's and Chief Justice Roberts' questions, and I don't think I can predict how this one will turn out. I hope personally that they will deny the applications, but maybe one thing that we can all predict is that in cases on the emergency docket, there's often not accompanying opinion. There's just like a one sentence order, but it seems like this is likely to be a case with perhaps multiple opinions, written with some reasoning that could provide some light on how the court sees the docket is going. So that would be really interesting.
Great. Well, thank you so much, panelists, for a fascinating discussion. And we'll, of course, be watching to see what the court does with this one. With that, I'll turn it back over to Emily to close us out.
On behalf of the Federalist Society, thank you all for joining us for this great discussion today. Thank you also to our audience for joining us. We greatly appreciate your participation. Check out our website, fedsoc.org, or follow us on all major social media platforms at FedSoc to stay up to date with announcements and upcoming webinars. Thank you once more for tuning in, and we are adjourned.